In this stream, no problem. We're going to be talking about the effects of the Supreme Court. If you were watching previously and you heard the voice of God coming from Rob Ryersey, pardon us. That was just a little technical difficulty that we had on my end with some sound. So I think we're in good shape now. We're going to be talking about the supreme effect on our society. Rob, I was saying, we're just going to start this whole thing over. For a long time, I listened to anti-abortion conservatives that I was hanging around with. And there was a period of time where I thought we should change the federal laws around abortion. I've changed my view on that. But when I was especially in that world, they were really hard on the Supreme Court, really, really chewing them out. I'm in the death penalty world, trying to stop the death penalty. And sometimes in that world, people are very opposed to the Supreme Court because the Supreme Court ruled in the mid-'70s to, again, reinstate the execution of our own citizens in the United States by our government. So a lot of us go, and I've been arrested at the Supreme Court steps, petitioning my government, this kind of thing. But I've never felt like one of those people that wanted to blame it on the Supreme Court, right? That said the Supreme Court's the problem. The Supreme Court is the thing that we really need to rally against. And, I never liked the phrase of, laws set by unelected judges. Remember when the conservatives would always say that? Oh, these unelected judges. They were talking about the Supreme Court. But now I understand what they're getting at. It makes a little more sense to me now because what the Supreme Court has done, this Supreme Court has now shown its true colors, what it's going to do. And in my view, and I'm interested in our commenters and your view too, they have chosen an obscure version of constitutional law to make the center of the Supreme Court. This kind of fringy, originalist, only what was intended or previously thought of by culture and society when the Constitution was written. That's the only thing that the Constitution references. I find it just unbelievably wacky.
Yeah. So, the Supreme Court has long been the primary front in the culture war. It was the reason. It was the reason Donald Trump was elected president. It's the reason why conservative Christians rallied behind him. Frankly, it was the reason, that George W. Bush was reelected, because William Rehnquist was, it had died, and the Supreme Court has, like, conservatives figured out that the place that they were losing the most was in the Supreme Court. And so they have had a full-scale attempt to take power in the court. And it has worked. It has been a plan that has been executed. Now, kind of phase one of that is to get presidents elected who will appoint quote-unquote strict constructionists to the Supreme Court, who will rule in conservative ways, and doing everything possible to make that happen, from blocking the nomination of Merrick Garland to ramming through the nomination of Amy Coney Barrett, and there has been a willingness to do all of that.
Yeah, look, conservatives, conservatives have been committed to that, but
and then the second strategy has been to win the state houses so that laws could be passed that can challenge existing laws and get to the Supreme Court, so that these rulings can be made. So it's been a two-pronged strategy that has been absolutely effective, and conservatives and the religious right has just, they have accomplished what they set out to accomplish.
Yeah, look, they certainly have. They've launched their attempt, their big takeover of the Supreme Court. So people know, because if you don't follow this stuff closely, you might not know like how the Supreme Court is supposed to function, that the Supreme Court and the courts as a whole, the judicial branch, is not supposed to be the electoral branch. It's not supposed to have its impact settled by politics. It's supposed to be an interpretive function free from politics. Now, I know that these current justices, the 6 that have ruled on so many of these cases, and 5 of those 6, excluding John Roberts, are trying to say, oh, we're not political. These aren't even our views. We're just interpreting the law. They are not. We would hope that they would be. It's what they said they were going to do. Remember so much John Roberts saying, look, I'm just the umpire, call him strikes and balls at the baseball game. I'm not the pitcher. I'm not the batter. I'm not the manager. I'm not any of that. I'm the umpire. Yeah, cute. We all knew, look, that the reason some of us were excited that there were African Americans on the Supreme Court, with Clarence Thomas, was a big deal, or that there were women on the Supreme Court, or that there's a Latino on the Supreme Court. Because we all know that someone's life experience impacts who they are as a justice. Of course. We're not going to live in a world where it's just somehow totally neutral and your political and your legal opinions. For sure, they're going to be affected by these things. But what these cats are doing, what they're doing right now, what they did in the Dobbs case, the abortion case, was basically said, oh, we're now going to go back and just say that cases were wrongly ruled on the first time. Normally what Supreme Courts do is say something had to change. Legal precedent is in place and the conditions have to change. You can't simply say this group of people disagree with those group of justices, so we're going to change it. That's what they did. That's what they did on so many of the cases we're going to talk about today. So for people who are in a conversation with their friends and so on about the Supreme Court, look, I don't think these people are on there because they're trying to push their own religious views. I really don't think it's their religious views. I think they're there pushing their own constitutional views. And as it turns out, their constitutional views are even more harmful to this country than just their own views. What we should not have ever done was said that if the makeup of the court changes, you can change the rulings. And that's what they've done, not just in the Dobbs case about abortion, but across the plank on so many of the cases that we're going to have a brief moment to talk about today.
Yeah, so a couple of things with this. One is, there is a real strong parallel that I can't ever unsee. I grew up in strict fundamentalism, the type of strict fundamentalism that, I grew up in a Baptist denomination that we weren't allowed to have anything to do with the Southern Baptists because they were too liberal, just to kind of, put it on the spectrum for you. And so I grew up believing and being taught and believing that the Bible was God's inspired, infallible, inerrant word. That the Bible in the original manuscripts was, without error and factual in every way. And that what we need more than anything else as Christians is to understand the Bible, to interpret the Bible, to observe. So we, had this whole Bible study method of observation, interpretation, application, where you take a look at what's in the words of the Bible, and you try to discern, what the author meant, and you figure out, okay, this is what the author meant, and then you interpret that, and then you apply it to your life, and it was very much an approach that was, the text of the Bible was the most important thing. The approach that these justices have to the Constitution is exactly that way. It is, what's the author's intent? What's the founder's intent? What do the words of the text say? And how do we interpret them? And the strict constructionist approach is exactly the same as the fundamentalist Christian approach to the Bible. And so I get it. I know this world. There's so you'll hear you know divisively said, people will say, oh well, like liberals just think the Constitution's a living document. Well, it's not a living document. It can't just mean anything that you want it to mean. It means what it means. And so that it really is a fundamental approach of how we come to understanding what the Constitution is and what its role is in in our lives, in our culture, in the life of our nation, in the same way that churches wrestle with this question about the Bible.
Yeah, and that's a great analogy and comparison. And what's true when people interpret the Bible the way you've described is they don't actually interpret all of the Bible that way, right? So they'll say, no, it means exactly what it says, and you should just do that. But it doesn't mean, that I should. Yeah. And then you fill in the blank. Yeah. There's all kinds of things. Well, that's the exact same thing that the Supreme Court has done. They took an approach to Dobbs in abortion and said, well, this needs to only apply to what it meant to the framers in 1849 and in 1907, like this. But when it came to guns, in the Heller decision about guns, Scalia's like, oh no, that means that you have the personal right to bear arms. Totally throwing out originalist,
the word militias
construction, and said, no, but that has an implication now. So the same thing that happens with a fundamentalist conservative reading of the Bible is like nobody's ever opened their Bible and read, Jesus said to the disciples, go into Jerusalem and prepare a place for me. No one has ever read that. No fundamentalist I know closed their Bible, got up, went to the airport, got on an airplane and flew to Jerusalem to prepare a place for Jesus to have the Passover. No, of course not. But when Jesus says to his disciples, love your neighbor, then they say, oh, that applies to all of us. So very specific things that Jesus has said to the disciples they want to do. Love your neighbor, bless your enemy, do good to those, who want to harm you. But the other things he says to the disciples, go and prepare a place for me. They're like, well, no. He only meant that to those particular people in that moment. But an hour later, at the very meeting that he had at the Passover meal, he said other things that we think do apply to us. They do that all the time. Of course you do, right? So this idea that there's just a fundamentalist reading, you just take it, you read it, you apply it to your life, and you go do it like it's some sort of like it's my guitar lesson manual where I'm just like, okay, put my fingers here and strum in this up-down pattern. That's not what the Bible is. Of course, it's not even what the Constitution is. And I don't want to make light of this because what Alito did in his writing, what Clarence Thomas supported, what Amy Coney Barrett also said that she was voting for, was a view of individual freedoms that if they're not articulated in the text, then they need to have a whole other set of conditions in place that are not met by all the other cases that carry this same weight. So we're really in a pickle where unless we put more people on the Supreme Court or something radical changes, people resign or have early deaths or something, which no one wants that, you're going to have this group of people, short of a mind change, running these kinds of decisions. And again, it's not just abortion. We'll go through a list of them that they did on this same approach. So what we have going on now in the United States is a Supreme Court that I think in my lifetime, and I'm old, so I'm going back to the mid-'60s. I think since at least the mid-'60s, maybe the mid-'40s, you've never had a Supreme Court that has changed its rulings simply based on its makeup.
Yeah.
With no rationale outside of, well, this is what the 5 or 6 of us think. They used to be held by hey, we may think this, but we're held back by precedent. They're not held back by precedent at all. In fact, they'll just come flat out and say, Roe versus Wade was wrongly decided from the beginning, and we're fixing that now. That's not your job.
Yeah.
Look, In fact, if Alito had made other arguments about why they wanted to overturn Roe versus Wade, science arguments or something else, fine, but they didn't. They made the old argument from 1978 that people have been saying that this was wrongly decided and we need to put new people on the Supreme Court to unravel it. It's maddening. Now, here's the other thing, Rob, that I don't know if we have time to talk today just about abortion. I heard the governor of South Dakota on a news program on Sunday.
Yep.
She was asked, this is Governor Noem, do you believe that women should be prosecuted if they abort their children in South Dakota? If that's now, because now a trigger law went into effect. She said, no, I don't think women should be prosecuted. Doctors should be, but not women. Now, look, I don't think women should be prosecuted either, but I also don't think doctors should. What legal basis do you have where only one person in this action is culpable? Yep. How do you say, doctor, you violated a law and, in our view of the state, murdered a human being, but the mother didn't? You can't have laws that do this. Even the view that this is a human being with full human rights and has been murdered can't hold up. That view is one that really does have to be challenged. And I know we've spent 50 years in this country arguing about abortion, and one side's been arguing about personhood, it's the conservatives, and the other side's been arguing about constitutionality. And the thing that we've ended up with now is two different philosophies of abortion that have almost nothing to do with each other. And it's going to be an implication across 50 states for the next 50 years. And it's just going to damage this country irreparably.
Yeah, totally agree. You know, one of the most interesting parts of this, when we talk about this, just throwing out precedent as an approach, precedent has been the way that in the Supreme Court confirmation process, there's always been this question of, is there a litmus test? Is there a litmus test? Is there a litmus test? Is abortion the litmus test? And that, you always get that thrown around. And then, you can't come out and ask, a Supreme Court justice nominee, are you pro-life or are you pro-choice? That would be a litmus test. And so the way it's been danced around, the way it's been talked about is this idea of precedent. Do you respect precedent? Will you uphold precedent? If a decision has been made, the law has been interpreted in a certain way, are you going to stick with that being the law of the land? Precedent. Amy Coney Barrett, Brett Kavanaugh, Neil Gorsuch, Samuel Alito, all in their Supreme Court confirmation hearings talked about that they would respect and uphold precedent. It was the way of saying, like, they didn't have to come out and say, oh, I'm pro-life, but I'm not going to rule that way on abortion, or I'm going to overturn Roe v. Wade, or I'm not, because if they came out and said I'm going to overturn Roe v. Wade, they never would have gotten through the confirmation process. But what they said was, I'm going to uphold precedent, and that allows for pro-choice senators like Susan Collins and Joe Manchin and other folks like that to vote for their confirmations. It turns out that they lied during their confirmation hearings and were in fact under oath when they did. Now, it's going to be real interesting to see. Like, you hate to see the court politicized, but the reality is that it is political because Supreme Court justices are nominated by a president who is politically elected and confirmed by a Senate that is politically elected and can be impeached and removed from the bench by the House of Representatives, can be impeached by the House of Representatives, removed by the Senate, who are all elected. Is there going to be any consequence for these justices who lied under oath when they said we respect precedent, and this is settled law.
Yeah, I differ a little
and
bit whether that's what they said, and I differ if what it means to uphold precedent is that you couldn't overturn a law. You can overturn a law. They do it all the time, right? I mean, that's what the Supreme Court does. There are all kinds of previous decisions that are overturned. The rationale for overturning them has to be there.
Right.
So you can respect precedent and still overturn something. They will make an argument, and I think it's unimpeachable, their argument, that the rationale that they have used is a legitimate reason for overturning precedent. I mean, there was no agreement when they were before the Senate in their confirmation process of what criteria would you use to overturn standing ruling of the Supreme Court or precedent. So I don't think you can constitute it as a lie. I think you can constitute it as every single person who voted for them knew that they would vote to overturn Roe versus Wade. Maybe not Samuel Alito, maybe, but Kavanaugh, Barrett, Gorsuch, they were all on a list and put on the Supreme Court because they were on a list of people who the activists said would overturn Roe versus Wade. So, yeah, I think, now trying to backpedal and try to say, well, these people weren't honest. Look, everyone knew. So I think that the greater damage is not just what did they say about this particular law, but this idea that they're applying a view of Roe versus of the Supreme Court in Roe, a view of the law, like on Roe versus Wade, in a way that's just really damaging. And look, you more on that, or do you want to look at some of the other cases?
No. I mean, I just want to say, obviously and understandably, the Roe decision has rocked the country and taken so much attention. And it is just one of many stunning Supreme Court decisions
that have come already this week and are going to come in the future. There's no stopping this train wreck of these 5 justices.
Yeah. Oh my goodness. And it is in American culture and life is changed. I now live in a state where abortion is illegal. It is, the law has been enacted and was triggered and it is illegal. A woman cannot get an abortion now in the state where I live. And look, culture has changed as a result of this. And, and so many of these other decisions are immediately shifting the cultural landscape in our country. It is stunning.
Yeah, and we will talk more in future streams and podcasts, as we have in the past, about the implication of abortion overall. Not trying to sidestep the gravity of this. It's one of the most important decisions.
Yes.
The impact is one of the most important. Also, we should recognize the way and the reason that they made those decisions is also important. Now, I know a lot of constitutional lawyers who are very pro-choice and think that that we should have a constitutional right for a woman to decide if she's going to continue a pregnancy beyond 19 weeks, beyond 20 weeks, beyond 21 weeks, right, in that ballpark, who firmly and vigorously believe that, and believe that the way Roe versus Wade was put together was not the best legal argument.
Yep.
That there are other better legal arguments that should have been put in place, and maybe in the future a different argument can come before the Supreme Court that's based on something that's not a version of the 14th Amendment. So if anybody's interested in that, just Google, Ruth Bader Ginsburg's view on the rationale for abortion for Roe versus Wade, and you'll hear her discussing this. She was a big proponent of, we could have had other cases that would have accomplished this differently, because the Constitution does support a right for a woman to not continue a pregnancy in the first trimester, addition to the arguments that were made in Roe versus Wade. because because the law is complicated, right? What you were talking about earlier is based on precedent. So there could be, but this rationale that these 5 justices have used and that John Roberts went along with in the Dobbs decision shows their hand about how they're choosing a kind of originalist interpretation of the Constitution that in legal circles is super fringy. Like when you have 50, 60% of the Supreme Court that has a view that 10% of the legal community holds, that's not a good thing. And that's what we have. And some of us who thought maybe these people will moderate a bit and modulate a bit away from that after they're on the Supreme Court as justices. Oh no, Clarence Thomas is just like, I've been waiting for these people my whole career here. And now here they are. All right, so here's the other ones that came down. There was one about religious school funding. Religious school funding said that, no, more money can go into religious schools than currently has been, and we don't have to limit where vouchers, state-funded vouchers go. If you don't know what this is about, every student in most states, every student has a certain dollar amount that's assigned to their education from the state, however the state gets its money for student education, whether it's from referendums or property tax or whatever. When kids would go to a private religious school in many states, the state said, you can't take that public funding and put it in a religious school. You can do it to a charter school or to another public school. The money travels with the kid. But as soon as you want to go to religious schooling, because it's not really about education alone, it's about religious learning, you can't take that money there. Supreme Court said, yeah, you can. Now, public funding of religious institutions and religious schools is enshrined in the law in a whole new way. This is enormous. It's not the personal impact and the effect of harm and death that the Dobbs decision, the eliminating abortion as a constitutional right is, but this is going to have great impact.
Yeah. And you know what, I went to Christian schools growing up. I spent time in both public schools and Christian schools and kind of bounced back and forth. I went to a Bible college that, yeah, there is in the fundamentalist and evangelical world that supports Christian education, there is a long-held belief that, hey, we don't want to take government money, because as soon as you take government money, then the government can tell you what to do. And that has, been often used, that, there's hiring laws, federal hiring laws, all sorts of Title IX, all sorts of different things, that as soon as you take money from the government, then you are required, in whatever form, then you're required to, play by the government's rules. This is just this feels like it's just some kind of like money grab that goes completely against the principles and values that we were always told, were the bedrock of what Christian schools were. And it is,
look, all of us reach our adulthood and we realize they lied to me. And then fill in the blank of your lie, your parents or your neighbors or society. Like, I didn't know what, that wasn't really. People in certain worlds, like the conservatives and realize, oh, that was really a lot of side talk going on. Hey, the reason we don't want government funding is we don't want them to tell us what to do, until they're like, oh, we're going to get $20,000 per student into this school. And okay, we'll take it. And now the Supreme Court has said you just can't make a determination that says religious schools don't get it and other ones do. I think it's states better put other precautions in place to keep this from happening. Funny enough, on this point, Rob, here in Minnesota, there was a similar court case that was brought up by a bunch of Republicans on the other side, because there's charter schools that are geared specifically toward people from East Africa. And the Somali community goes, and they have religious education as a part of the public charter school. And they were trying to argue you can't use money to fund Muslim education. When this comes around the other side of the horn and these Christian conservatives start to realize that public funding is going to fund other religious schools, not just Catholic parochial schools and conservative Christian, elementary and high schools, but it's going to other schools. It's going to be an interesting cultural conversation for some of those people because that's not what they have in mind when they're thinking public. It might be what the Supreme Court has in mind, but curiously enough, it's not what comes up. Hey, here's another one: Medicare. This one's, I think, not quite so, hinging on whether the Supreme Court has a particular view or not. But it was a big one today. It was about how health services can calculate the number of low-income patients, and so it's kind of a technical health and human services impact case. I don't know that many people think a lot about it. We'll have great precedent, and we'll make budgeting decisions for insurance companies and for hospitals and for Medicare. I don't know that it really feels like it impacts too many individuals. Do you have any opinion about that?
I mean, unless you're one of the low-income folks who's, trying to get some medical care.
Yeah, I'm just saying their decision may or may not. I mean, it might just have to do with how adjustments are made. It's I feel like that one sort of passes. This one's a bigger deal to me. Voter ID. The Supreme Court said on Thursday that 2 Republican leaders of the North Carolina legislature could step in to defend the state's voter ID law, even though the state's attorney general, who's a Democrat, was already doing so. So this voter ID law was like, oh, let's just have open season inside of states, and having the U.S. Supreme Court tell North Carolina how it's supposed to manage its own voting laws. It's curious because they wanted to say, let's let the states decide all that stuff when it comes to voting, and now they're stepping in and telling the states how to do it.
So,
it's
this
going to put more government officials inside, more conflict inside of discussions about voting rules.
So if I understand this correctly, this is less about the voter ID law itself and more about the process that it is defended. So, North Carolina passes this voter ID law that you have to have voter ID, that ID to be able to vote. That law is challenged by someone who doesn't have ID but still wants to be able to vote, and so the Attorney General of North Carolina goes to court to defend the law and argue in its favor, which is, the Attorney General's job. These 2 Republican leaders from the legislature don't think that the state Attorney General is defending the law that they passed adequately.
Right.
And so they are stepping in to the role of Attorney General to take that responsibility to defend the law. Right? So this is a procedural thing about the separation of powers. We live in a country where powers are separated between 3 branches of government: the executive branch, the legislative branch, and the judicial branch. An attorney general is a part of the executive branch. Their job is to go before the judicial branch and argue either in favor or against the laws that have been passed by the legislative branch. And for these 2 legislators to take the role of the executive branch is a gross distortion of separation of powers. And this is a deeply troubling decision, because what it does is it basically says, hey, listen, elections don't matter. If your state legislature passes something and some wackadoo individual state legislator who wants to defend that in court, they can. And who you elect to be your, here in Arkansas, for instance, we actually elect our attorney general. Many states do. If you elect someone to be your top judicial representative of your state, we're just going to nullify that. It doesn't matter. This is a
Yeah, I don't know.
stunning.
I don't know that they're saying it doesn't. I think they're saying you and the state don't get to decide if it matters, right? They're saying the federal system will intervene and give rights to legislators, even though your state system says they don't have the right to represent the defense of the law. I'm not sure it's conclusive. In other words, it could go the other way. So a state could decide the opposite of that. The Supreme Court is saying, "Oh, you don't get to decide that on your own." I think that's what's most egregious about this, is that it's federal court stepping in. And this is the thing that's happening with conservatives over and over and over, is they used to say, we don't want big government and we want the feds out of our state business and out of our personal business. Let states decide. So they do Dobbs abortion, which is push this back to the states. They can figure it out. Then on the voter ID law, they're like, states can't seem to figure out how to manage the defense of the law. So we're going to tell you how to manage the defense of the law. Yeah. It's this just fundamental. I mean, this is the thing with the Supreme Court. The Supreme Court often shouldn't be deciding the legality, the impact of laws set by states. They should be making sure that no one's constitutional rights are being violated. Here, I just think there's no way a court 10 years ago would have voted for this, the support of this law. Yeah. No possible way. It's just another indication that this makeup of the court, all bets are off. Yep. Or all bets are in, or the rig is in. All right, here's a beautiful one. Instead of just getting rid of the death penalty, they ruled that, a Georgia death row inmate can reject lethal injection and call for the firing squad. Now, this people might not even know, because no one wants to think about capital punishment, but in some states, they've had a very difficult time getting lethal injection protocols in place. They can't get the chemicals to kill people because the drug companies won't sell them to the states. In some states, you can choose, if you're on death row, how you're going to be executed. There was an inmate who didn't want to be executed by lethal injection, so he wanted to die by firing squad, and that's not authorized in the state. And the Supreme Court said that the inmate could bring the challenge under federal civil rights laws that allow individuals to seek remedies with their constitutional rights if their constitutional rights are violated. So it could make it easier for inmates to challenge their potential execution methods. Siding with the inmates, at least, that on how the state's going to kill them, they should have a say in it. Just let that settle in for a minute. The same people who want to make sure that women can't stop a continuation of a pregnancy also want to make sure the state gets to decide how they're going to kill someone. It's just baffling to me. All right, since we got to hustle up, because there's a lot, they just continue to double down on the Second Amendment, this time saying that New York's law that said you could prohibit who has a concealed carry permit was unconstitutional, and you can't put extra burden on people who want to carry a gun outside their home because, you have the right to have it in your home, said the Heller decision when Scalia broke with, constitutional originalism. And now they're saying, you can't have laws that make it harder for someone to carry a gun around than harder for them to carry a gun in their own house. Yep. Again, beautiful idea. Make sure more people are carrying guns.
Yeah, because, the Second Amendment really is about, how you conceal carry your musket.
Did a whole video on this if anybody wants to see the absurdity Rob is bringing up here. Yeah. And that is, it all depends on the power of the comma that follows the right of the well-regulated militia, comma, shall not be regulated, close. The right to bear arms, comma, the right of a well-regulated militia, comma, shall not be infringed. So does that first comma conjoin the two, right to bear arms and militia, or does it separate the two? And literally the decision of the Supreme Court to say that individuals have a right to bear arms, not just a militia, which we'd now call the National Guard, hinges on the comma.
Yeah. So
Poor grammar in the Second Amendment. And a little side note, what you'll find out in that video, many of the states that ratified the Second Amendment, their version of the Second Amendment that they voted on didn't have the first comma. In other words, we're not ratifying the view that Scalia put forward in the Heller decision.
Yep. Now, listen,
I would dare say, Rob, if I can interrupt you one more time on this, I would dare say it was wrongly decided from the beginning, and we should just go back and just unravel the decision.
Oh, wrongly decided from the beginning. Wrongly decided. Like I've heard that before.
You've been wrong from the start.
So, listen, there are those that are gonna make the argument that okay, here is inconsistency. Here's the hypocrisy. In the Dobbs decision, the Supreme Court is saying the states get to decide, and here they're striking down a state law.
Yeah.
Well, and listen, I get that, but the counter argument to that is if you take their belief at face value, is that the state law is not allowed to contradict the U.S. Constitution. And if the state law violates or contradicts the U.S. Constitution, then it is the Supreme Court's job to strike that law down. There is not an inconsistency in their position here. Now, kind of on the surface, it looks like it, but there's not. The problem is not that they're being inconsistent about quote unquote states' rights in this situation. Mm-hmm. The problem is that they are completely misapplying the Second Amendment, which was, never conceal carry a handgun in the most populous city in the country.
Well, in any city in the country, yeah, in a dead empty city, the Supreme Court didn't bring.
But I'm just imagining, the crowded nightclub in New York City that now has, 50% of the people conceal carrying.
Well, and to be clear, this decision didn't go as far as it could have. Now, look, every decision that the Supreme Court looks at is a tough one. That's why it's at the Supreme Court. It means that there's been a court case has been ruled on, then an appeals court had to rule on it, then the Supreme Court looked and said there's a good argument on both sides. So every case that the Supreme Court has ever looked at, someone can say, hey, there's a really good point here that they didn't agree with, for sure. So this is why I think picking on the Supreme Court is just not normally the path to follow, because the reason it's at the Supreme Court is that there's really good, smart people who know the law who are arguing the other side, always. It wouldn't be there if that wasn't the case. It would be like Trump's Stop the Steal cases they tried to bring before the courts. They just threw them out because there is no case there. If it's at the Supreme Court, there's a good argument on both sides. So you can always go to any Supreme Court decision and take the side that didn't win and go after it, right? For sure. Yep. That's normal. The problem with this Supreme Court is the reasoning and the rationale that they've used in some cases. What they're doing is they're messing with case law, and case law is all you have. When you go before a judge, you're expecting that judge is going to stay within the bounds of the law. That's what they do. The judge can't simply say, well, this is the law, but I don't care. I'm going to rule this way. That will be overturned because the law dictates what the laws have to be. In this case, who knows now? The Supreme Court is just like, nah, we just think it was wrong from the beginning. We're going to move on to something else. All right, I got to go here in a minute. So look at all the rest of these. Can't talk about all of them in the same level of detail.
Miranda Rights. This one.
Rob, you have the right to remain silent. Have you ever been told by a police officer you have the right to remain silent?
I have not.
Oh, it's a real treat. Yeah.
This is
I've often said to them, and you have the right to remain silent too. So why don't you take that and zip it? Well, they don't
This
appreciate
is
that.
a stunning decision. So basically, what this decision is that the Miranda Rights, which if you watch Law and Order or whatever, you read that your rights are read to you. You're reminded of these are the rights that you have when you are being taken into custody. the Supreme Court ruled that if a police officer does not read you your Miranda rights, you do not have legal recourse to sue that police officer. So what this does is, first of all, it significantly reduces the consequences of not reading someone their Miranda rights, and it further expands this idea of immunity that
for officers.
Police officers can do whatever they want and not be sued for it.
That's the big one. Look, we should just enshrine. We shouldn't wait for a police officer to have to remind someone that you don't have to speak to a police officer. I have a friend who was a police officer, and he said this. He said, look, never answer a police officer's question. He said, in any circumstance, never do it. Even if you're not arrested, if an officer just pulls you over and says, where are you going? If you're walking down the street and the officer says, are you having a good day? Don't answer them. He said, this is what we do. We use the things that people say against them all the time. You don't ever have to answer them. Sometimes there's a consequence if you don't. They might take you into custody and hold you longer, but you never have to sit. Now, I think that's a more extreme position, but we should just push through our society the reminder and not wait for an officer to have to tell someone who's being apprehended that you do not have to speak to a police officer and you have the right to representation. And if you can't afford that representation, one will be provided to you. This should come to people when they are, graduate, when they do their 5th grade graduation class, which I still don't understand why we have 5th grade graduations. But a 5th grade graduation class, it should be like, here's your diploma. And if you're ever around a police officer, you have the right to remain silent. And if you have the right to an attorney, and if you can't afford one will be provided for you. That is just something we should be embedding and not waiting for police officers to yell or whisper it in someone's ear when they're incarcerating them. We've had this for 50 plus years. But you're right. It's really about, again, protecting more police officers. And speaking of protecting people that didn't need protection, Coach. Okay, I got to go. We can't get through all these. Can't even talk about these. The coach. We got to come back another time because I got to go.
Man, I know you got to go. Justice Sotomayor included a photograph in her dissent on this prayer football coach decision. Unbelievable. Talk about precedent. Unprecedented.
Yeah, that they couldn't separate, that the coach, it could somehow say, I'm a coach now. 5 minutes after the game is over, I'm not the coach. I'm no longer a school employee. So this doesn't mean you can have. Now the good thing is they didn't say you could have prayer in school. They actually said this ruling actually reinforced a separation between public roles of people working in schools and prayer. So
no, it didn't.
It did.
Which is exactly what.
No, it did. What it did was it said, because the game was over, because it was a public space on the field, they went to great extent in this case to make this argument. The people who wanted this to be a gateway into prayer in school are very disappointed at the argument around it. It didn't accomplish the thing they wanted to accomplish. Hey, I have to go, partly because we're going to be back in 2.5 hours because the select committee for the January 6th hearing has called a very special get-together today. We're going to be live streaming it over on our YouTube channel only. So if you watch this on Facebook and you want to watch this with us at 1 Eastern, 2 Central, noon Central, 1 Eastern, 11 Mountain, 10 Pacific. I don't know what it is in Hawaii. If you want to watch that with us, come and join us over there on the Facebook, on the YouTube channel for Vote Common Good. If you're watching on Facebook, you got to go over there. We'll post a link there. But that's where you'll see it. All right, Rob, sorry I got to cut it short. Well, I don't know. When you do 49 minutes, it's probably not short, but sorry I have to stop before we were done. But I got to go. Okay, we'll talk to you all in a bit.
Bye, everybody.
All right, I got to go. I'm on child care duty.
Okay.